Good day, everyone. My name is Marta Kindres. I'm a director of Advocacy and IT Industry Development Center at IT Ukraine Association. Some words about IT Ukraine. The association was founded 22 years ago. Today, we represent more than 250 technology companies, and we are Ukrainian national representative in Digital Europe. Today, we are representing ITU Global Talks on 5 legal mistakes when working in Latin America. Our speaker today is Gilda Orozco, Senior Legal Counsel at Alcor, a legal partner of IT Ukraine Association. And today, we will discuss 5 important areas: misclassifications of contractors, intellectual property rights, data protection, local tax, and regulatory requirements. Hilda, thank you for joining us today. The floor is yours.
Hi, thank you for that introduction. I'm very happy to be here. Okay, I see the presentation is running. Okay, perfect. Hi, as you have heard, my name is Gilda Orozco, and I'm a legal advisor at Alcor. I am based in Mexico, so that's the accent that you're hearing. And you will hear today some practical examples and real life cases about what I have learned from working with tech companies. And yes, many examples come from Mexico because that's where I'm based, but also you will hear some other insights from relevant tech hubs in that region. So, without further ado, let's start. So, just to give you some perspective about the size of this opportunity that LATAM represents, I included here a map of Mexico. And Mexico's population is right now around 132 million of people. If you compare that to Poland, Ukraine, and Romania, that combined population it's still compared to Mexico, 40% more. Mexico has around 40% more population than Ukraine, Poland, and Romania combined. Um, and because of that, companies look at LATAM as a major opportunity because strong specialist talent. Also, because of the convenience of overlapping time zones that can happen with the United States and also with Europe, and flexible ways to build teams because it is not necessary to have your own legal entity in the region in order to hire contractors there. However, there are some hidden challenges because of that. As many companies, when they start wanting to expand into LATAM, they see the contractors model as the main opportunity, as it looks as a familiar model. As when doing a quick research, it might look like something very similar from the compared to the country where you currently operate. Um, However, there are some local differences that we will cover today, specifically about employment, some tax considerations, IP transfer, privacy, data protections, and so on. So, as this introduction included, the topics that we will be covering today will be contractor classification, permanent establishment, the real cost, intellectual property, and data protection. And I will start with the first mistake that I believe is the one that brought many of you today to this talk, which is misclassification. And the first mistake is treating a contractor agreement as enough to create a contractor relationship. And this is because I've seen many companies consider that just because this agreement has the label independent contractor agreement, then that's the only concern that they need to take into account. And once this is covered, then they are safe from this misclassification risk, in which authority reclassifies a contractor and and sees it as an employee, and because of that, employment benefits, social security, and other employer liabilities would apply. So usually the agreement will have the standard. It will say that this is an independent contractor relationship, that each party is responsible for their own taxes, and the acknowledgement that no employment relationship exists because of this agreement. However, what authorities also examine through this engagement is not only how it is written in paper or what is specified in the agreement, but how this looks in practice. So there are different triggers and some specific LATAM indicators that authority weights a little bit more compared to the European or Ukrainian model, which we will cover today. But I wanted to also say is that there are different factors, and there is not like one that will automatically lean or cause misclassification. However, because of time accruing and also different factors combined, this risk is increased. So yes, what can move a contractor relationship toward employment? Here I included 6 factors. First is independence. So having this control over how the work is performed, how the deliverables are handled, the methods used, and these specified in detail as instructions or even orders, it's a main trigger for this misclassification. Next would be having a working schedule. So if this agreement also includes like the wording of that the contractor shall be available from 9 a.m. to 6 p.m. From Monday to Friday, this is also a major trigger that can lean to be equally as if it was a working schedule. Next point would be supervision, as having daily direction and manager start reporting can also be relevant here. For example, using some tools as Jira, asking some tracking and reporting from the contractors can also help increase this risk. Next would be the payment structure. And this is also something to consider, because I have seen some agreements that specify the specific amount that the contractor will earn, and usually comes with like the contractor accepts to receive this fee for I don't know, $500 per week, etc. So these fixed amounts that look like they are not agreed by the parties, but that they are imposed by the company, the hiring company, also is a major indicator that the relationship or that this payment of fees is actually a salary in disguise. Um, the fifth one that I have for today is tax documentation. And speaking about these in detail would require a full session, honestly. But well, something that I want to share with you is that Mexico, Colombia, and other Latin regions that are mimicking Mexican style are very have very detailed invoicing systems. So just to give you an example, authority will know the moment that a contractor issues an invoice, they will receive them the same day, and they will be able to identify the concept, the amounts, and some patterns that might occur. So tax documentation is also something to be very careful about in terms of concept, in terms of frequency and amounts. And the sixth main trigger that applies would be employment style benefits. We already spoke about this payment structure that might look like a salary. This would be one benefit, but there are other perks that might apply and also are might look a lot like some employment benefits, such as 13th month salary, also some profit sharing, some professional training, provided equipment. And these benefits on their own do not necessarily mean that a contractor will be reclassified. But the way that this is framed might also affect. Um, for example, it's not the same to say that the company will provide this laptop for the performance of the services, that included in the agreement that the parties agree that because of the nature of the information that will be transferred from the company to the contractor, they will require some specific tools which might be provided by the company. So these slight differences on writing make a huge difference in the impact of how this relationship is built. Now, all of these six might look very familiar to what you have heard in Ukraine or in your region. However, there are some other LATAM specific triggers. Um, Specifically about Mexico and Colombia, so the personal services can trigger a presumption of employment, which means that if one contractor presents a claim in front of the labor authorities or labor courts here in Mexico, um, the authority will assume that this is actually employment, and it will depend on the company to prove that it wasn't. So the burden in order to demonstrate that this is actually a contractual relationship of services relies on the company. And having only one IT services agreement or services agreement will not be enough, honestly, in practice, in order to prove your case. So there are other documentation that might be relevant, such as invoices, such as SOs, purchase orders, etc. And in Brazil, something interesting is that they have some recent developments in which they consider digital supervision equal to direct supervision. So it doesn't have to be in-person supervision or instructions in order to be considered like this might be a misclassified employee. So they weight more also this type of supervision in order to qualify or reclassify a contractor. Moving forward, um, now you are probably wondering, okay, I see all of these uh, indicators and I understand this misclassification risk, but what can I do in order to mitigate them? And I can summarize these in 3 points. One of them would be having clear documentation. So having these services agreement, invoices in which the services are defined, the payment is also agreed, the taxes allocations is defined, confidentiality, IP and termination. This is one important component to keep in mind. Next would be strategic operational practices, because managers or finance team and the operational team should operate the relationship in line with the intended agreement model. So they should be mindful about these triggers and be able to flag any differences, and also uh, structure this payment in order so it doesn't look like monthly or recurring payments of the same fixed amount every month. And a third aspect is this ongoing monitoring, and this goes both in what I just discussed, how it works in practice in day-to-day activities, but also ongoing monitoring on terms of um legal precedents, legislation, how this is changing, because it might benefit, it might become less restrictive, or it might become more. So it can both it can work both ways, and it is always worth considering. So in a nutshell, contracts, operations, and ongoing review would be relevant here. Now, moving forward, I want to address the next mistake that I have seen these tech companies make. And this is one that it is constantly overlooked, which is building a local team without assessing permanent establishment. So, what is this risk? Permanent establishment is having a fixed place of business from a foreigner company um, in a host country, which would cause some taxable presence. So more or less, that would be in plain words. And there are some misconceptions about what can cause a company to have a permanent establishment, because if you go briefly through this concept, you will hear and learn that it requires some um, fixed place of business there, or that it requires to open an office, or even to have a legal entity in this country, so a local legal entity. However, a foreigner company can create a taxable presence through activities performed locally by employees or contractors, meaning it doesn't, you don't need to have this specific employee working there, or this fixed office there, in order to for the authority to consider that you have raised a permanent establishment there. Uh, and what factors can be can affect this? Well, or not what factors, but also what frameworks are applicable here. Usually, it is domestic law, uh, like the tax code of this country, and also applicable double taxation treaties. If there is a double taxation treaty between these two countries, both the one that it is hiring from the services and the one that it is performing the services, then this double taxation treaty might apply, and define the specific triggers that will raise a permanent establishment, even without incorporating a legal entity. So now, just to explain this in more detail, there are some other circumstances that can make that this permanent establishment is assessed by the authorities. And one of them is the length of the duration of the provision of services. And this is something that might happen inadvertently, might when assessing this situation by legal teams, and it might start like, we might hire a contractor for a month um, because of a specific project. But then this relationship evolves, the scope extends, different components are added into this deliverable, etc. And then it's 4th month. But at 6 months, something very interesting happens, because many of these double taxation treaties and these domestic laws mention that after these 183 days within a 12-month period of services being performed in a country, that this sole activity will create or generate a permanent establishment of this foreigner company within this region. And these might expand, and the more it lasts, the higher the risk, since this project might be reassessed as a permanent establishment, just because of hiring a contractor in for example, Colombia. And during this period, the contractor might issue these invoices that will act as evidences of this permanent establishment or of this ongoing provision of services that will be able to be framed within this 183 days threshold. So my advice here is to track the actual days of service performed in the country and consider different strategies in order to not overpass these 183 days. Okay, so next would be some examples of LATAM specific examples that might be even beyond that. So it doesn't require to have just one single contractor for these 183 days threshold, but the other triggers that might apply. And one of them is this UK-Peru double taxation treaty, which specifies that it is not required that the services are provided within this frame of days by one individual, but it mentions that if the same company, foreigner company, is hiring, for example, Peruvians, and if this company is hiring 2, 3 contractors, even if they are hiring them through different filials or related companies, authorities might reassess these as connected activities, and and assess that this company has or must have a taxable presence in Peru. So this is just one specific example of why it is relevant to not only assess this as a generic way or as a LATAM fully applicable threshold, but always look into these exceptions. Not because you already learn how to operate in Colombia means that you can use that same framework in order to operate in Costa Rica. So the differences might be slight but relevant. In practice, as I said, this is not considered in complete isolation because this exposure is being monitored. So what to monitor? The days, the actual local service days, the activities. And this is one aspect that it is very relevant because if this contractor is signing agreements on behalf of the foreigner company, has some manager position, or is somehow a decision maker, these might also impact on how the authorities will assess these and consider that a permanent establishment has arisen. Group exposure, we already discussed this, it is relevant to not consider this in isolation, but also the different contractors that are being engaged within the same project. And always check for these both local rules and double taxation treaty rules. A permanent establishment or PE monitoring might need to happen at enterprise or group level and not only person by person. The third mistake that we will go and discuss today will be budgeting the payment instead of the real cost of the engagement. And yes, you probably have heard that in hiring in LATAM a developer is much cheaper, that the salary expectations are lower than compared to an American or European contractor. However, something to keep in mind is always to budget not only using the base salary and multiply it by 12, but consider the different components of these. And as I said, evaluate them because these might significantly change from country to country. For example, in Mexico, a company needs to budget around 30% of company taxes on top of the salary of an employee. When in Chile, a company needs only to budget around 10% more on top of salary. So the differences between countries also are very relevant here. So first, I will discuss these employees, and you have to consider this base salary as discussed. These statutory benefits, such as 13th month salary, vacation premium, seniority premium, and other benefits that might apply into these employees. Also, local and municipal taxes, which might be connected to these payroll contributions and social security contributions, and also termination exposure. As yes, this engagement might include some risks, and severance payments and terminations payments might be up to 3 to 4 months, depending on the specific country that you hire. If we don't consider this employment model, but this contractor model that we have been discussing, the basics you need to consider is the base salary plus any agreed bonuses that you provide to the contractor. These are not mandatory, of course, but also worth considering. Applicable withholdings, these are also very relevant, specifically for anything that can be framed as consultancy services or as royalties according to double taxation treaties or domestic law. So please always review if there are some applicable withholdings and applicable VAT, as there might be some cases in which these services qualify as an exportation of services, and in most cases VAT wouldn't apply. However, there are some exclusions to always to always consider, and specifically if the tech company has also clients or products or services within the region in which the contractor is located. So the recommendation is always compare jurisdictions using the total annual cost, both if you are deciding to hire people as employees or as contractors. And now we will discuss in more detail some these employment benefits that might look or might be entirely new to you, but I wanted to include here some three basic examples of how these benefits can significantly change the budget that you need to consider. The first example that I will discuss is Colombia, because in that region, employees have a benefit called cesantías. And cesantías are the equivalent of 1 month salary that the company has to pay to a third party fund, the cesantías fund. And each year, they will send this money to this fund, and in case of a termination, regardless of whether this was a necessary voluntary resignation, etc., the employee until then will receive the money. However, it is 1 month additional to the 12 months that you already have to budget for. Another benefit that Colombian employees have is that they receive something called prima legal, which is the equivalent to a 13th month salary. So this bonus is paid also, well, 2 times per year, but it's equal to 15 days each, so 1 month of salary per year. So now only one Colombian employee has already costed 14 months of salary for the company, and we haven't even discussed the applicable employment taxes. So Colombia at its own might be on the more expensive side when considering other regions. But Mexico has something different, also worth noting. So eligible employees have a benefit called PTU, which the translates to profit sharing. So companies need to every year after they make their presentation of taxes to pay and distribute 10% of their tax gains or profits within all of their employees that were engaged under the previous year. So um, this benefit is something that employees receive every year, and the amount might vary depending on, of course, the profits. But for some employees, these amounts might be even more than the equivalent of 1 month salary or 2 month salary. So um, that's why it's also relevant sharing. And Chile has its own version of it, which is gratificación legal. And in there, authorities allow companies to decide two models: whether they want to distribute and pay 30% of their gains once a year to their employees, or to pay monthly an additional bonus to their employees of 20% of the equivalent of their salary. So, yes, these three are just some examples, but in many Latin countries, they have some form of 13-month salary, profit sharing that that companies need to budget for. And other benefits that are common are these different statutory bonuses. For example, something that comes to my mind is Colombia's case, in which certain employees are eligible for some clothes allowance, meaning that the company has to provide like clothing for the employees and even shoes for their employees once a year. Also some meal benefits that have to be meal allowances that have to be also paid to the employees. There are also some vacation related payments, so some vacation premium. This is applicable, at least I know, in Argentina and Colombia, in which during the days that the employee is on vacation, you have to pay an additional amount of these bonuses. Social security contributions, of course, these might be very different. And I have heard some feedback from Ukrainian colleagues specifically about how complex social security contributions might be to calculate in LATAM. And of course, termination costs. As discussed earlier, this can be up to 4 months of salaries, so probation periods, and budgeting correctly, it's very relevant because of that here. And in addition to these general benefits, also another layer to consider is the taxes. We discussed employment, but some of these taxes might also apply to contractors, such as withholdings as discussed, some indirect taxes as VAT, local taxes as these Colombians industry and commerce tax, ICA, which applies and is paid to the specific city and the rate where the contractor is located, and the specific amount varies depending on the city. And some cross-border rules such as treaties, double taxation treaties, taxing rights, and foreigner tax laws. So what drives the treatment is who pays, both in terms of the tax regime and country of this where this payment comes from, where services are performed. If in a different city or different country, the tax treatment might change significantly. Recipient's tax status, whether this person is in a special tax regime or not, and domestic or cross-border engagement. So we already covered this part. So the actual cost of this engagement will require that companies run the tax analysis for the specific country paired with the engagement model. It's not the same to hire employees than contractors, and in all cases, I can say it is cheaper to hire a contractor than an employee. Moving forward, the fourth mistake to discuss today would be assuming your standard IP clause works everywhere. And this is something that might be overlooked by companies that have like one standard a contractor agreement that they apply globally to all their contractors, because how these rights are, I mean, the scope of intellectual property rights, the transfer, and the benefit of the gains of these products significantly change from country to country. And one major gap here is that some companies will just include some common law wordings from the United States, as this concept of work made for hire, which uh, in most Latin countries doesn't apply. What this concept says is whoever pays owns the deliverables of created during the or made because of this payment. However, in Latam, there are not many exact equivalents of this legal form or figure. So several Latin jurisdictions do not have statutory rules allocating economic rights to employees or clients. So it's also something that needs to be addressed in the agreement. Including there might be some specific cases for software, which we will discuss next. But the idea here is to understand that the conditions, scope, and formalities vary materially from one country to another. And in order to explain this in more detail, so when a contractor or employee uh, creates some deliverable that includes these inherent intellectual property rights, the individual creator might remain legally recognized as the author. And these this has different rights that might be covered because of these deliverable. One of them is the economic rights. So the right to exploit this IP, who can commercially exploit the work, use any applicable licenses, a right to reproduce, commercialize, and so on. So these economic rights are one thing, and something entirely different might be moral rights. The rights connected to the author, that these are usually non-waivable and very protected in many Latin jurisdictions. So you might think, okay, but if I include in my services agreement that the applicable law will be California or somewhere in Europe, then this domestic law wouldn't apply. But that is not actually or entirely true, because foreign law might govern the contract, while mandatory local copyright rules can still affect the authorship, the moral rights, and infringement connected with these. And I will give you some examples of how there are some slight but relevant differences on how these countries view economic and moral rights. So, starting with Mexico, there might be some agreement with an employee, the employment agreement, that doesn't specify anything about a IP transfer. So the authority says that if this is not covered, economic rights might be shared, so split in 50% for the company and for the employee, unless otherwise is agreed. So it's very relevant to make sure to include these provisions in the agreement if that's the case. Now, there are some specific rules about creation of software, because the law specifies that economic rights belong to the employer when created as part of the employee's duties. Meaning, if this employee, was hired as a software developer, and then the software developer creates this software or generates this software, the authority assumes that this software belongs to the company just because of the nature of the deliverable. Colombia establishes their own model, saying that if no IP rights are described in the employment or services agreement, then there will be a presumption that that these there will be a transfer just on the scope limited to the necessary ordinary activities for the company or the employer. So these might be transferred, but only those that are essentially necessary. So all these know-how or documentation might not come into this package. And moral rights remain with the author. Same with Mexico. These are non-waivable. These are rights that must still be recognized of the contractor or employee. And something that I also wanted to share with you is that AI is changing the game significantly in these LATAM countries, because there are different decisions made by courts regarding IP ownership of things created using AI. And one example of here is a Mexican court which in 2025 ruled that if an IP is AI purely generated, it doesn't qualify for copyright protection under the rule discussed here. So even if you claim that you own the AI that was used to generate this deliverable, even if you have this license in your favorite AI, um, or even if you drafted the prompt that led into that deliverable, still this is not subject to copyright in Mexico, and cannot be registered accordingly. So it's always for AI assisted development to consider whether there is enough material into this deliverable that can still be connected or considered as human created. So always check what was created, by whom, under which relationship, and under which contract. So um, not having this one rule per all Latin countries will be recommended, but check specific regulations, and as you can see, court decisions regarding IP transfer and ownership in the country in which your contractors or employees are located. And okay, last mistake that I will cover today will be applying one global privacy process across LATAM. And this is a topic that it is currently in an evolving phase, I would say, in LATAM. In some countries, it might not be as advanced as European GDPR, for example. However, this is constantly growing, and and there is an increased revision of what needs to be formally made in order to guarantee the correct handling of personal data. So companies might have this global privacy framework, might only just translate these into Spanish or into Portuguese, and then apply it across all of their teams. However, there are some local implementations differences in how the consent is given, what are the requirements depending on the specific type of data that it is being collected. Some international transfers that might be different, and also the type of consent that needs to be collected because of that. There are some obligations to register some databases, which we will discuss later, and some additional local authority requirements. Even adding some specific labels are required in this privacy notice or privacy policies. And I want to discuss some short example of how these rules might apply to you without knowing. And let's just think of an scenario of a company that it's interested in hiring a contractor, let's say in Chile. And this contractor first shares their CV. And this CV includes general information that makes this person identifiable. And because of that, some collection and definition of the applicable scope and uses that will apply about the information that is being collected will apply. Also, okay, you decide to move forward with this contractor, and you ask for some identification documents or some banking data, background checks, or just some performance information that will definitely qualify at some point or level as personal data. Even having photographies in CVs might qualify as biometric data. Therefore, it's relevant that companies consider this applicable framework, and that even if they have no local presence in the country from which this person is being hired, is relevant to keep these privacy notices updated and localized depending on the specific regions from which they are collecting personal data. And there are some differences on how these the levels of detail or company requirements might be different. So, for example, in Colombia's case, authorization is very relevant. They divide authorization from consent and say that just because you accept a privacy notice doesn't immediately qualify by its own as giving consent, for example. Um, Also, there's some specific obligation to register databases, and some companies are eligible for registering all the databases from that they might have that include Colombian citizens. Mexico, on the other hand, it's more focused into what is included and described in the privacy notices. So these are specifically regulated. We have different types of like short version, long version, depending on the type of information that it is being collected. And it has to include these controller identity, data and purposes, use limitations, and these access and these Alcor rights also need to be covered and described. So access, rectification, cancellation, and opposition rights should be defined of how the subject can access to these rights. And Brazil would have one of the most advanced models in terms of data protection in LATAM. They have their own version of GDPR. However, the LGPD, which is Brazilian equivalent, has its own framework in which there are multiple legal bases, local requirements, and potential extraterritorial application that are also worth considering. So my recommendation here would be to keep the global framework. Yes, that's a great practice. However, map the local deviations country by country. And something that might also be considered is that foreigner companies might not still be subject to this enforcement. However, there are some examples of how this actually happens. In Peru, Colombia, and Brazil, they have had different cases in which they have fined companies such as Meta, Google, Uber, WhatsApp, because of the way that they handled personal data that was not compliant, even if these companies did not have these legal entities within their territory. And you can see here that, for example, in Peru, this fine was around 260k um, for Google. Also, Brazil had a case in 2024 in which the authority had to force Meta to stop using personal data for training generative AI systems, and they set a fine of 9.6k if they did not comply with this. So even in these cases, you can see that there might be some extraterritorial enforcement from these countries. So, location of headquarters does not necessarily determine the regulatory reach of these. And yes, so just to finalize what we discussed today, and as a way to summarize some of these advices, would be to, before entering a country on your own, run the following diagnoses. Understand the local rules. We saw how these might affect in terms of employment, tax, IP, and privacy. Choose the engagement model depending on your or preferences and priorities, of course. It can be either employee, contractor, or just some supported model by a third party. Calculate the real cost. We discussed that these might have some deviations significant considered from a base salary. Protect your IP. Make sure to have um, a specific a clause or agreement that ensures that you have the economic rights, and that you that these IPs rights are transferred to you from the moment of their creation. And of course, get local advice. Now, you might hear, or you might think that at this point that hiring in LATAM is very complex, that probably you don't want to do it anymore. However, what I wanted to say is that LATAM is open for business, that it is very large. We discussed that even in population wise, it is significantly big. And of course, if you don't want to deal with all of these on your own, if you don't want to set your own legal entity within this country, or even if you just want to test the waters and see how the talent is in this region, you can always rely on EOR or core providers in order to help you to scale in this region. At Alcor, this is something that we do, and we are happy to help any company that wants to enter into this market. So that would be it from my end.
Hilda, thank you very much for such practical presentation. And we have also collected some questions from our participants. So the first question, you have already covered this question during your presentation, but if you have something to add, we will be very happy to hear it. So the first question is, if IT company works with a contractor in Latin America, what are the real risks of the relationship being reclassified as employment? And what are the main tools companies can use to minimize this risk?
Mhm. Yes, so the risks we already discussed: subordination, supervision, discontrol, lack of dependence will always impact. And as the ways to mitigate these, we discussed 3 points that are very relevant. Keep proper documentation. Do not only rely on these services agreement as the only proof that you might have of these structure of independent contractor. Next, always be mindful about these operations. Consider the length and the of this provision of services. And third, constant monitoring. So both on the operation itself and also on local rules. And my advice would be to be mindful that this model might not be might require you to transfer at some point these contractors to employees, just because of the level of risks might increase over time or over the different aspects or even company policies that are required to be applied.
Thanks a lot. The second question is how important is language when doing business in Latam, and is it generally sufficient to working with clients on English?
Okay, so there are many. So, in terms of hiring people in LATAM, you can find many people that speaks a good level of English, specifically in countries such as Argentina, Colombia, Chile, and I would say Mexico. In terms of population, there are other places like Panama that also has a great level of English speakers, but not so many in total. And on terms of on these agreements, these can be signed in either English or in Spanish, or even two columns in English and Spanish as preferred. So it is not a stopper. You can always hire from this region without speaking the language, but of course, it's recommended to hire people that speaks the language, and I can guarantee you that there are plenty of them.
Thanks a lot. The third question is are the established approach in Latin America countries to providing benefits to contractors, and what will be the risk for reemployment?
Okay, yes. So benefits, of course, if they look a lot like salary or employment benefits, these have to be addressed and provided carefully. So I gave an example of, for example, purchasing of equipment, but this applies to the different benefits. For example, it's not the same to say that you have a sick leave days than to say that you have some interruption of services because of unavailability of the contractor and so on. So of course these can be given, but these have to be framed both written and also among the teams carefully in order to not resemble significantly employment benefits.
Thanks. And we also have questions in chat, so we would like to hear from you about outsourcing ban in Mexico. If we hire developers as contractors, could it apply prevent them from providing services to our overseas companies?
Okay. Not necessarily. Okay, so this outsourcing ban is something quite new in Mexico. Still is in process of of how it executes. However, what I can say is that it applies mostly to domestic operations. So the main focus of why this outsourcing ban was created in Mexico is because uh, companies, Mexican companies, were purchasing services instead of paying salaries. So the major target for local authorities is the not the recipient local company, not the company providing these services. So if these contractors are hired through a third party, I would recommend, of course, um, could it apply prevent them from providing services to overseas company? I would say no, because as I said, this ban is mostly focused into domestic operations and still can be framed. There are some exceptions, some REPSE registration, and some other relevant exceptions that could apply. But these apply to employees, not contractors.
Thanks, quite understandable. So the second question, could you please provide some basic information about the reps requirements? Specifically, would reps apply to a Mexican company that has only one client, which is its US-based parent company?
Okay, Repse is here. So could you please provide some basic information? Yes. Um, okay, this is something very relevant and might answer this person's question. So, in order to get this Repse, you need to register with a labor authority and say, I will provide services to companies whose main commercial purpose is not the same that I have. So, for example, if the Mexican company is an IT company, and the client company, one client, is also providing, is also an IT company, then this REPSE registration won't be applicable, and it will be a non-compliant REPSE registration, and you will probably lose it. It's okay to have one client. There's no need to have multiple, but the main distinguish or differentiator here that would be risky, in my opinion, would be having the same purpose of that the company that it is oversees.
Thanks. The third question is about personal data. Is a wet signature required for employee privacy notices, or can this be handled electronically in a simpler way?
Yes, so in the examples that I gave, for example, Mexico, Argentina, Chile, and Colombia, it can be handled electronically, no problem.
Maybe it is the all questions that we have. Thanks very much to Hilda. And for our participants, if you still have the questions after the webinars, you can use IT Ukraine Yes Support service. It's a free 1 hour service consultations available exclusively to our association members. The consultations provided by our legal and cybersecurity partners. And exactly, Alcor also is a legal partner. We will share the link to the Yes Support page in the chat so you can see and use them. And thank you everyone for joining us today for ITU Global Talks. I hope the discussion was useful for you. See you soon on our next IT Ukraine Association webinars. Thanks.